So next up we have Sawnie McEntire from our Texas firm, Parsons, McEntire, McCleary, and Clark. And Sawnie's going to talk about sex and power. I'm just kidding. He's not going to talk. Or maybe he is, because he's going to be talking about how to grab the attention of a jury by way of opening statement and how to prepare the most effective opening statement you can prepare. Most of us lawyers will wait until discovery is complete until we start fashioning our opening statement for trial. But Sawnie is going to show us a better way to prepare a winning opening statement. Standing between you and your afternoon of Florida sunshine is Sawnie McEntire.
I'll make it briefly. Okay. Good afternoon. As I was introduced, I'm Sawnie McEntire. I'm from a firm in Texas, and my topic is effective opening statements. How to prepare, deliver, and present the opening statement. And I need to start off with a disclaimer. I can look around the room. I see lots of familiar faces, and there are many very highly skilled trial lawyers in this room, and I would not pretend to suggest how each of you would prepare your opening statement. But what I do want to do is underscore what I think are some key features of how we get to that point, because it's really not an opening statement, in my opinion. It's the first final argument. And I approach my opening statements in that fashion. An opening statement can win or lose your case. And I want to talk a little bit about how my experience, how plaintiffs' lawyers are approaching the opening statement. Some of you may be familiar with a doctrine, or a strategy actually, called the reptile strategy. And it goes something like this. The plaintiffs' lawyers believe that there's some substrata in the lower brainstem that instinctively makes us all want to seek out personal safety and security. And they hone in on that desire and that instinctive need. And that's what inspires their opening statement. It inspires how they prepare their cases. It inspires the anger that they try to create with the jury through fear. And that's why when you get into a high exposure personal injury case, catastrophic injury case, or even a high exposure commercial tort case, you're going to hear things like greed and danger and kill and malicious, because they're appealing to something that's not necessarily logical. They're appealing to something that is very subliminal. And it's very important, I think, for the defense lawyers, and most of us are defense lawyers. I think all of us are probably defense lawyers. We need to know how to respond and rebut to that. And where's my clicker? Is this it? Okay. All right, so opening statements, it's an opportunity. As I said, I think it's your first final argument. It's a pivot point in the case. You're not there and you don't prepare your opening statement on the night before, the day before. It's not the week before, in my opinion. It's the culmination of weeks or months, in fact, in some cases, years of planning. It begins at the very first step when the case comes into your office. Because what you're doing, you're identifying what you think are your key trial themes, the themes that are marketable to an average jury, themes that they can seize upon and have a hook, a marketable hook. It's only one of three occasions that your lawyer, that we as trial lawyers have to talk to a jury. Jury selection, opening statement, and final argument. And I don't believe that an opening statement should be used as simply some boring overview of what the evidence is expected to show. I think that it's incumbent upon us as defense lawyers to be more proactive and go after the guts of the case and appeal to the instincts of the jury. I think you need to come out with a bang. And another reason you need to come out with a bang is because the attention span, we live in a technological age of sound bites. Your average juror attention span is not long. So if you have a 30-minute opportunity for an opening statement or a 45-minute for an opening statement, you're not going to hold all those jurors' attention for that entire period of time. So you need to come out with a bang and something captivating, a hook of some type. Will Rogers said, "You will never get a second chance to make a first impression." That's a fairly trite, a little amusing statement, but it's so true. And so when we walk into the courtroom and we're about to give our opening statement, we're not going to lecture the jury. We're going to talk to the jury. We're going to personalize our clients. We're going to try to present something positive about our clients. because the plaintiff's lawyer is doing just the opposite, trying to inspire negativity in the courtroom before you ever stand up. It's very important that from the very first stages that you begin to communicate trustworthiness, credibility, and an emotional hook for your case, and of course, logic. We started at a disadvantage. William Shakespeare, some of you may be familiar with this quote from Henry VI, but basically, the trial lawyers start off at disadvantage. The first thing we do is let's kill all the lawyers. I guarantee you, when those jurors walk in for jury selection, they're looking around, they're scared, they're fearful. They see these lawyers. Lawyers have, in many instances, in many venues, have a bad reputation. So you start off already being suspicious, or they may distrust you, and you have to allay that and develop your rapport with the jury very quickly. You don't lecture the jury. You talk with the jury, and you personalize yourself and your client. This is a war. It's basically the rules of engagement are such that you need a battle plan. A battle plan are your blueprints for a successful trial. A battle plan are your trial themes that you've been working from day one to develop. What you want are cogent trial themes, simple trial themes, nothing complicated. You don't want too many trial themes either. You want to reduce it to a few that your decision makers can take back into the jury room and become your advocates. And what do I mean by decision makers? Through the jury selection process and opening statement, my guess is you've already kind of locked in, made my contact with one or more of the jurors. You know who may be kind of leaning towards you. You have that instinctive feel, okay? And so you want to start talking to those jurors, because those jurors may become your true logic advocates back in the jury room during the deliberations. I believe, and I believe jury science research will support this, that there are basically 4 types of jurors when they walk in for jury selection. They're going to fall into the strong plaintiff box, the weak plaintiff box, the weak defense box, or the strong defense box, depending upon the venue and where you practice. Some venues, you may have a lot of strong plaintiffs jurors. Some venues, more conservative, you may have a lot of strong defense jurors. This is their preconceived bias and orientation when they walk into the courtroom for jury selection. And what happens in opening statement is like a game of marbles. What you're trying to do is you're trying to capture as many marbles and put for the defense lawyers and put them in the 2 lower boxes. When the plaintiff's lawyers do their opening statement, assuming it's an effective one, you're going to see a pattern, a movement. Some of your strong defense jurors will become less strong. They're going to have some doubts in their mind. Some of your weak defense jurors, well, then maybe they're beginning to lean just a little bit for the plaintiff. And some of those weak plaintiff jurors, well, they may now have just been bought. So your goal, your objective, your challenge, and your burden as a defense lawyer is to reverse that trend and reverse that pattern and get back the marbles and put them in your box. And that's how you stymie the momentum. So this is not just an overview of evidence that becomes boring or pedestrian or pedantic. What you want to do is you want to come out with a bang and grab their emotions. An opening statement should be used as an opportunity for advocacy. And this advocacy is the elements of this advocacy are over 2,000 years old, 2,500 years old. It's born with Aristotle. Pathos, logos, and ethos. Emotion, an emotional catch to hook the jury. Logic, logos, a coherent, internally consistent presentation of the facts. And credibility. Everything has to be credible. The lawyer has to be credible. The client has to be credible. Your client has to be credible. So this is the 3 cornerstones. If one leg falls, you're in trouble. I will suggest to you, though, that the plaintiff's lawyers focus less on logic and logos than they do on emotion and credibility. A lot of jurors won't even pay attention to the logical presentation of your case. After the first 2 days of the case, they may be less concerned about the logic and explanations that you're providing. They've already filtered all that. And now they're just going by their gut instincts and emotions. And that's why the plaintiff's lawyers focus on emotion and credibility. And they want to talk about all the negative things. They want to talk about how your client was greedy. They want to talk about how your client did that or did this, was malicious, was consciously indifferent, was evil, was selfish, was dangerous. in the appropriate case. And the plaintiffs and defense lawyers, we have a burden to respond in kind. Aristotle said that the character may almost be called the most effective means of persuasion. I believe that is true. Over 2,000 years ago, it's true today. If your client is not believable, if your client's key witness is not believable, you lose the case. So what you need to do is, as you approach your opening statement, you want to have the most credible witnesses, the most credible explanation of what happened. Because if you lose this battle, the table will fall. One of the three legs will collapse and the table will fall. So, in opening statement, I think it's our burden on the defense side of the table to talk about the ethics of our client, the morals of our client, that our client is principled and socially conscious, a good corporate citizen. I'm not talking about what happened in the individual event that's at issue before the jury. I'm talking about all the other good things that the client did. How the pharmaceutical company saves millions and millions of lives. How the car manufacturer is innovative in the areas of safety. I'm talking about the good things to start characterizing the client in an appropriate way to appeal to that instinct in the lower brainstem of the jurors' minds. Logos. This is the explanation. This is why we're here. This is the defense. This is what really happened. This is what really did not happen. Don't believe the other side. This is our explanation. Believe our side. That's the logos. It's still very important, don't get me wrong, but I will suggest to you that a lot of jurors don't even pay attention to this after the second day of trial. They've already made up their minds because it's made up back here and in their gut. Pathos, the emotional reaction. Every action must be due to one or other of 7 causes: chance, nature, compulsion, habit, reasoning, anger, or appetite. I'll suggest to you that the plaintiff's lawyers care for very few of these. They're only going to focus on a few. They're going to focus on compulsion. They're going to focus on habit. They're probably not going to focus a whole lot on reasoning. That's the logos part of the deal. They're going to focus on anger and appetite. An appetite for greed, an appetite for money, avarice, anger, the fear that they'll try to inspire with the jury. Early planning is critical. And what do I mean by that? Planning is bringing the future into the present so that you can do something about it now. Well, what that means in the context of what we're talking about is you don't prepare your opening statement the night before you give it. The ideas have already been percolating for weeks, if not months. You already probably have prepared a general outline of what your key trial themes are, or you certainly should have. If you wait too long, you're going to miss the opportunity to ask the critical questions in depositions. If you don't know what your trial themes are when the depositions start, you're not going to have an opportunity to ask that crushing cross-examination question of the adverse expert. You may miss the significance of that one document that suddenly becomes Exhibit 1 for the plaintiff's case. So I suggest to you that your opening statement is not an opening statement. It is a culmination of all the hard work that you've done up until that point. And it's the synthesis of all the hard work that you've undertaken. It begins on day 1. First steps, you identify your trial plan. You identify the key legal principles, the favorable facts early, and the bad facts early so you know how to deal with them. You have to deal with the bad facts, and you have to deal with them effectively and efficiently. You develop your themes, and you begin to try to neutralize those bad facts. So every step of the case, I think the big takeaway from this chart is this. Every deposition that you take, I believe, I submit to you, to all the trial lawyers in the room, every deposition that you take is a trial deposition. Your singular goal is to advance favorable facts. Your next goal is to neutralize negative facts. And all of these depositions can be used in one form or a fashion when you finally get the jury in the box. And they are the cornerstones of your ethos and your pathos and your logos in your opening statement. And so the final steps, not the opening steps, but the final steps are your opening statement. And here you are. You're using your demonstratives, you're using the evidence that you've developed, and now you're putting together an effective package. So every step along the pathway of trial development is undertaken with the goal and the objective of incorporating emotional catch, a positive emotional catch, portraying your client in the best possible light, a credible, logical explanation of the event or occurrences, and of course, you want to be trustworthy and credible. If you lose that part, it's over. So I want to talk about just a few. I have a few more minutes. I'd like to talk about a few examples and cases. The first one is a chain with a red link in it. This is a case I tried last November. A lot of dollars were involved. I actually represented the plaintiff in this case. And this case dealt with the assertion of a wrongful lien on assets, on my client's assets. And we opened the case with the idea that this liens and these security interests were wrongful and had to be vacated. It was a chokehold and a stranglehold around my client's neck. I showed this precise chart twice in opening statement. I used it with their experts. I used it with our experts. And in the final argument, I had my videographer burst the red link and say, this is what I'm now asking you to do. I want you to exonerate my client and vacate the liens. We got a favorable result. The next example is more of a logos argument, an explanation, but it was repeated over and over and over again, and it was put in very simple terms. I represented, I had the privilege of representing a real estate broker in a breach of fiduciary duty case, and he was being accused of losing an important real estate deal. And the explanation was he didn't do anything wrong. What happened is that we had a colossal national and regional collapse of the real estate market, and all the values plummeted to the toilet. And I repeated that during all of the expert examinations, during fact witness, including the plaintiff's depositions. You've heard of the collapse. You understand the collapse. And I was getting positive feedback and admissions in the testimony. All that came and pulled together in the opening statement, was used effectively in the opening statement throughout the trial, and we did get a defense verdict. Another example. I had an opportunity, again, this is a plaintiff's case I was involved in. I was representing a company going after a friend of Enron. A friend of Enron was basically an off-balance sheet entity that was not a directly owned subsidiary, but for all intents and purposes was controlled by the C-suite at the Crooked E. So we repeated the name Enron frequently throughout the examination, of getting ready for the depositions and the expert depositions, getting ready for trial. We repeated it throughout the opening statement, throughout the trial, and throughout the final argument, and we were successful. I think that is probably the best example I have of the reptile strategy, because you're appealing to people's sense of insecurity in the face of catastrophic financial distress. The next example is an example where I represented homeowners who actually all their homes were built around a tarmac, around a landing strip. And the landing strip, however, was owned by a third-party developer who wanted to convert it to commercial property. And we claimed that we had an easement, an ingress and egress easement. And the analogy is, it's like their driveway. Make it simple so they could understand it. I was appealing to something that they could rapidly understand. No one wants to be prevented from driving their car in and out of their garage. These people were prevented from driving their car out of the tarmac. They were being prevented to drive their planes, and that's how they got to and from work. Another example is repetition, a rollover case involving an ejected occupant, a death case. The plaintiffs claimed that the fellow was wearing a seatbelt. We claimed he wasn't wearing the seatbelt. We had all kinds of logical evidence, no load marks on the belt, no witness marks on the belt. Didn't look like the belts were being used. But that's a horse race. It's a horse race because we're dealing with someone who's dead. And the jury could go either way. What broke this case open for us, and we were in a very difficult venue, is as a small town in southeast Texas, one of our key witnesses was a local Baptist minister. And the local Baptist ministers confided and testified that somebody had confided in him, an occupant in the car, that the gentleman who died was not wearing a seatbelt. Bingo, bang. We had instant credibility with the jury. That case was a defense verdict. I'll do one more. And this is a case dealing with, I would also call it the reptile strategy. My firm was involved in representing a pharmaceutical company. We tried 4 cases to trial. Two defense verdicts, 1 plaintiff's verdict, and a mistrial. This is a situation where the plaintiff's lawyers consistently tried to portray my client as a killer. Use those words. My client was putting out medicines that killed. My client was putting out medicines that had tremendously and devastating side effects, death. Our response, my client was putting out medicines that saved lives. Let's talk about penicillin. Penicillin has side effects. Some people die of penicillin, but think of all the millions of lives that penicillin saves. So the idea here is we're not just addressing and responding to the accusations, we are going above them, and we are playing the plaintiff's game, and we are responding in kind. So this is how I would end my presentation. I believe that opening statements are actually the first of your final arguments. I believe that opening statements is not just providing an overview of the evidence. It is your first opportunity to really advocate in front of the jury and reflect and incorporate all the work that you've done up until that point. My time is up. Have a great afternoon. Thank you.